Alright, grade 9, I hope that you're doing well. In today's session, we will speak about advocacy skills in litigating practice, meaning that what are the needed skills for the advocacy. For the past semester, we have already speaking about the advocacy campaign, how to launch our campaign, how to identify our allies, how to set our goals and our tactics, and how to set a whole plan for anticipating what's going to happen in our advocacy. So today we're speaking about the needed skills for your own litigating practice. To start with, we will speak by training for courtroom advocacy. Some of you now are going to become lawyers and they will be in the courtroom. How can they advocate during being in the courtroom? We have some objects today. Some of them are: the aim is to identify the mechanics of law, students for advocacy in courtroom scenario. So imagine now we are in the courtroom after launching our campaign. Remember the example we have given about the company that needs to establish a new branch, and it's very, very harmful to our own environment. Imagine that we have advocating towards them, and right now we are in the courtroom after several problems between us and now how we can just advocate in the courtroom, and what is the scenario that we are gonna follow. So to start with, what is advocacy in that case, and who is an advocate, and what skills does an advocate possess during being in the courtroom. Advocacy is the act of pleading or arguing in favor of something, such as a cause, idea, or even a policy. In our case right now, we are speaking against a country, or against the killing of infants, children, or even speaking about the illiteracy in some countries, and that the number of unemployment is rising. All of these are problems and ideas and causes that need us to advocate in favor of. And of course, that's in the courtroom. You can just be in the courtroom advocating about some problems and taking some actions. An advocate. The advocate is any person who speaks up for and defines the rights of him or herself, or even another person. Like, for example, the problem of unemployment. So we can advocate about this problem because it hurts a lot of people. A lot of people now are unemployed. Consequently, they don't have enough money to raise a family, and this will lead them to very, very bad situations. Some of them can steal, some of them can just try to do anything against the law so that he can obtain money. So we are advocating the person who advocates in favor and defends himself or even another person. That's called an advocate. Advocacy, of course, refers to the efforts of an individual or a group to effectively communicate and convey or even negotiate. In that area, we're speaking about how we can use the advocacy in order to implement or amplify our own efforts, or the individual or the group's efforts, in order to communicate with those who can able or who are being able to solve our problem. Like, for example, if you are speaking about the problem of illiteracy in the whole world. So we are addressing communities and we are addressing governments in order to solve our problem. How can we present our case? How can we advocate in its favor? And how we convey and negotiate with the other governments in all over the world in order to solve the problem of illiteracy. About some advocacy skills which are needed in order to just convey your own goals. Number one, we have communicate effectively. So If we are addressing the problem of unemployment, so we shall communicate effectively with our government. We will speak to the government, telling them that we have a lot of kids now and a lot of young men who have already graduated, yet they cannot find any job. This will lead them to do something against the law, and this will increase the hazard of the society, and our community will not become safe. So find all the causes that can make your communication effective in the eye of the person you are advocating. And of course, it can be just one person, a group, a government, a community, whatever your advocacy plan is about. Interviewing clients. Remember when we spoke about how to bring allies for your advocacy campaign? Can you remember? While speaking
Yes.
about the allies and how to collect allies and find potential allies. So interviewing clients, this will lead you eventually to gather more people around your advocacy campaign and the plan you are doing. Because by interviewing people, okay, right now I'm making a change. For example, if you are speaking about the problem of unemployment, I'll bring an unemployed person and I'll start to interview him and ask him about the problem he's facing and is he doing, how can he get money, if he has a family, how he spends money on the family. And by doing that, I'll show all of that interview for the public eye. Then the public eye will just come to join my campaign, and by that I can gather more people in my campaign, and also I can pressure the people or the person I'm advocating so that they can change their mind, which in this case, of course, is the government. Drafting capability, showing your own capability and how to draft it in order to fit the situation you are in. Negotiating settlement and agreements. So, negotiation is one of the most important skills while advocating for something because you cannot always win by 100%. If we are speaking, for example, about a factory for chemical hazard substances, which is being constructed here in our city, and we need to stop that factory. So the factory has already got all of its papers and everything is set, so we cannot just stop it. It's going to be against the law. So we need to learn how to negotiate. So instead of dumping your waste in our country or in the sea, you need to take it and just burn it or even bury it inside the desert, thousands of miles away from our city. So try to negotiate so that you can get to some situation which is beneficial for both you and the person is who you are advocating. Number five, facilitating early resolution of dispute. So just try to become easy. After all, you are doing something good for the people. So whatever you can get for the people, it's totally acceptable. So try to facilitate to become easy. And of course, representing your own client. Your client here is the person you are advocating for. If you are advocating for unemployment, so your clients in that case can be the people you are speaking for, those who are unemployed, or if you are in a courtroom advocating for someone, which is our topic today. If someone has a problem in the court and you are advocating for him, so represent your client with all possible means. So know everything about him and also try to just present your case as simple as possible and just show your point of view and your client's point of view so that everything will turn in your favor at the end of the day. If you are in dispute with someone, dispute like a problem with someone, it would be beneficial to approach it in such a way that there is be no loser. Because after all, we are people and none of us loves to become a loser. In other words, it's called a win-win situation for all parties. Like if two people have a problem and they went to the courtroom and you are advocating for one of them, try to study the whole situation, the whole problem, and after studying the whole situation and the whole problem, just try to make your best so that your client will not lose anything, and also the person in front of you will not lose anything, or he will not lose a lot. So try to have an approach of a win-win situation for all parties. If you are not capable of doing that, just try to solve the problem as simple as possible, because after all, none of us loves to become a loser or even to lose anything. It means that the other side needs to see the effect of not compromising. Meaning that if the other party or the person you are advocating against, he has done a problem and he does not see that problem, or he can't imagine that what he has already done is considered to be a big problem. So you just need to grab his attention to the possibilities of the problem he has already made and what also will be the consequences of that problem. Once he comes to seeing that, in other words, we can say just try to implement your own point of view by applying your point of view to the advocating party. Consequently, they will come to see your own situation and understand what's happening in that situation, and they will change their mind and try to come to the win-win situation. For this, of course, the council has to ensure, number one, the reasonable injury, confidentiality, and the disclosure beside the natural justice. Of course, while being in the court, you have counsel, a jury, a group of people who are in the court, and they will determine whether you are right or wrong. In that case, you must just be reasonable for the injury. The person I'm advocating against, he's making something bad, and this thing will lead into an injury or lead to a bad situation. You have to become confident about your cause, what you are advocating for. You must be confident in that thing. You must believe in it. Otherwise, the council will just not believe in you. If you don't believe in yourself, no one will believe in you. The disclosure, which means to end uh, the problem, and by ending the problem, this means try to find the easiest solution, which will help you eventually. And the natural justice, just always advocating for the right thing. Do not advocate for a bad cause or a wrong cause, because eventually justice shall reveal. So how can we do it? The most effective strategy is to agree in principle with what is being said, but not but to present a slightly different perspective or spin on it, so that it goes in your favor. So, one of the most important strategies while advocating in a courtroom, okay, you have to agree in the principle. So, if I'm having a problem with Abdurrahman and both of us went to the courtroom, we must agree right now on the principle, okay? And after that, try to present slightly different perspective, okay? All right, Abdurrahman, you are right, and everything is okay. But on the other hand, there is a problem of one and one, okay? And by just grabbing the attention to the other perspective, to the other point of view, then the jury or the judge or the people in the courtroom will start to take your favor, and it will go very, very well eventually. So try to be calm, try to just have the ability to manipulate the words so that you can present your own perspective. And after presenting your own perspective, this will lead that the people will take your favor eventually. In India, for example, we have Mahatma Gandhi, for example, in India. During the process of EDR, the existence of judicial intervention is so limited. Like Delhi High Court, for example. So, while presenting in Delhi High Court or advocating in Delhi High Court, just to try to be calm, easy, and grab all the people just to see your own perspective. Hence, the advocates for the parties to the dispute have a limited area or scope to maneuver. Consequently, you don't have enough room so that you can just present your whole case. So just try to be easy, and by having that limited area, choose the correct way or the right way to present your own perspective. Okay, so it's not like, for example, the court in America or the court in England. Okay, because now the advocates have a limited area. So just try to maneuver, meaning that to manipulate or to have the chance in order to present your own perspective. Judicial intervention, of course, in proceeding and awards of arbitral tribunals reduce the efficiency of this ADR mechanism. However, such intervention cannot be wished away, meaning that unfortunately we cannot do anything in order to change the situation, but in order just to manipulate our words and try to make our best to present our own perspective. Later, the bending nature of a word does not mean that the courts do not have a role to play in arbitral proceeding. Courts often assist or interfere according to the boundaries of law, meaning that if the problem I'm having with Abdurrahman concerning the law, then there is no need for advocates because simply the court will interfere and they will help to just solve our problem. On the other hand, if that problem between me and Abdurrahman or between two parties or two people or even two companies is not concerning the law, it's ethical one. Consequently, now we need to interfere and grab the attention of the court to our own person. Or in other words, we can say it's synthesized in the arbitration law. Hence, there is a need for the law, of course, students to be duly synthesized. Just a second, please, boys. Okay, guys, sorry for that. So, and the framing of an arbitration agreement. What's going on and what can we do? Abdullah Al-Farayan, can you read, please?
Avoid engaging bias, teacher. Bias.
Yes.
Fraud, misconduct, corruption.
All right. So avoid to engage in all of these: the bias, the fraud, the misconduct, and also the corruption. After all, remember you are advocating right now in a courtroom. If you are to be caught by stealing or manipulating the law or doing something bad, like fraud or misconduct or corruption or even the bias, all of these things are very, very bad in order to just being caught doing them. And by doing them, this will just lead you to lose your case. And we do not want to lose our case. After all, we are advocating so that we can win our situation and present the person or the group of people we need to just have the rights. And also use of video as a teaching aid. Video tabbed demonstrations showing aspects of focused role play. These tabbed begins stimulate discussion on the points depicted, meaning that, for example, we said that we have a problem between two parties. Okay, if you have a video that can show and present your own perspective and point of view, then just use it because, or even a picture. There is a proverb that says, "A picture worth 1,000 words," meaning that if you have a picture, there is no need for speaking because I have a proof right now. So if you have a proof like a videotape or a picture of any of these seen things, you can just present them, and by doing that, they will just help your cause very, very much. In conclusion, we can say that, for example, in 1891, Sir Fruncha Mahatma Gandhi, of course, had the following words for advice for M.K. Gandhi: rest assured that it doesn't take extraordinary skill to be an ordinary lawyer. Common honesty and industry are enough to enable him to earn a living. Vakal should know human nature. He should also be able to read man's character from his face. Okay, that's Sir Mehta and that's Mahatma Gandhi. Meaning that, rest assured, guys, it doesn't need to be just super ordinary in order to make a cause or to make a change or to win a situation in the court. All you need to do is just to be honest. Be honest for your cause and be honest for yourself. And always try to show your own perspective. Always try to show your own perspective. Because by just showing your perspective for other people, this will help you to just win their loyalty, and also they will become allies for your own cause. Eventually, you will serve your own cause. Any questions so far about that?
No.
Welcome to the Lawyer's Think Tank. Many a times, you must have thought that what do you need to become a successful lawyer in your life? Your answer is here. All you need to do is just develop a set of skills within you. Now, which are these skills? Are they just listening skill, speaking skill, or writing skill? No. As a lawyer, you need to develop some other special skills. Advocacy skills is one of them. So today we are going to see advocacy skills in detail. Basically, advocacy is the practice and skill of a lawyer. It is said to be a skill of persuading. In a nutshell, persuasion skills means the ability to make intentional and successful efforts at influencing someone's mental state through written or verbal communication, whether it is a college presentation or lawyer's advocacy. Persuasion skills are essential for success in every stage of life. Advocacy also involves convincing people over any case facts. When a legal advisor puts forward a particular argument to a court with a view to persuade the court to come to a decision favorable to their client, it is known as advocacy. It encompasses with a range of abilities including case analysis, drafting, using arguments, making oral submission, and cross-examining witnesses. It is about being able to put forward a strong and persuasive case. So this was just a brief information about advocacy. Now friends, just try to understand it in detail. It begins when an advocate meets a client and continues as the case is prepared by doing research, and then case documents are prepared when it is finally presented for a trial. It is most obviously applicable in context of court litigation. However, it is also extended to arbitration, legal advisors, counselors, etc. An image of an advocate or a lawyer arguing in a court is naturally the first image that comes in mind when we say legal advocacy. In fact, it is the act of pleading for or arguing in favor of something or actively supporting a cause or proposal. It means representing the interests of the client in the best manner possible. It is considered as an art in which lawyers are trained. Advocacy skills are crucial in shaping the outcome of a case. This is what advocacy is. But now you may think that how can we develop this advocacy skills? So now we are going to see the ways to develop advocacy skills. The very first way is mooting. Mooting is one of the best way for developing advocacy skills. It involves all steps necessary in advocacy. It essentially means a mock trial or a mock or dummy court. It is a platform where legal issues are raised by hypothetical court case in a dummy court. In a moot, all the abilities of recording, analyzing, preparing, presenting, and arguing as well as debating are put to the test and developed. It helps in critical thinking as well, and also applying laws to the facts. In a moot, every advocate presented with a case researches and analyzes a moot problem and prepares a skeleton sketch. The advocate then gets a set of time to present the legal argument and respond to any interjections by the moot judges. The aim is to present best argument and be the most persuasive advocate. Mooting helps the individuals to understand the weaknesses and how they can build upon them is also understood by mooting. Another way for individuals to develop the advocacy skills is observing a trial. This is done by the senses of observing. Observing trials develops a confidence among the individuals as they can see real-life examples of good and bad advocacy as well. If you notice an advocate putting forward outstanding arguments, ask yourself why their case seems to be so powerful. Make notes and enjoy experience. It becomes a good way to understand what advocacy feels like and witness impressive advocacy skills. Also, other than this, if you develop your drafting skills, it can also help indirectly to develop your advocacy skills. So guys, this was just short information on advocacy skills. If you wish to know about it in detail, please let me know in the comment box. And do share it with your friends who are aspiring lawyers. Thank you.
What, grade 9?
Hello, greetings to all my sisters and brothers.
Any questions so far about how to advocate in a courtroom?
No, thank you.
Okay, that's good. That's gonna be it for today, grade 9, and see you next session.